And welcome everybody to this opening session of the 2024 International Fair Trials Day Conference. My name's Tony Fisher from the Law Society of England and Wales, and before we start I'd like to first of all say thank you to a couple of people in the audience for joining us today, in particular Justice Adolfo Acuna and Dean Pacifico Agabin. There are many other people that we need to thank, but most of them are actually on the panels and will be introduced during the course of the day. So before we start, I'd like to provide a little context for the day's events before introducing the speakers for this session. In 2021, a group of lawyers and lawyers' organizations came together to establish this annual International Fair Trial Day, to be observed every year on the 14th of June. The initiative was supported by over 100 bar associations around the world, all of which are committed to the vital importance of the right to a fair trial and the serious challenges to fair trial rights worldwide. They established a steering group for the organization of the International Fair Trial Day, and that steering group has done an enormous amount of work together with your local bar associations to arrange this conference today. The steering group agreed that in each subsequent year, one country where fair trial rights are being systematically violated would be chosen as the focus country, and the event would be organized to mark International Fair Trial Day, as well as a series of activities around the event to draw attention to the situation in that country. The events include holding this conference on systematic fair trial issues and making a public statement with concrete recommendations on how to tackle these at the end of each conference. The decision to establish the International Fair Trial Day was also accompanied by the establishment of the Ebru Timtik Award. Ebru Timtik, if you don't know, was a lawyer from Turkey who lost her life on the 27th of August 2020 as a result of a 238-day hunger strike. She undertook to protest against the systematic violation of fair trial rights which people in Turkey are facing. Every year on the occasion of the International Fair Trial Day, the Ebru Timtik Award is granted by an independent jury to an individual or individuals or an association who have or which has made a significant contribution to the defense and promotion of the right to a fair trial in the focus country. We meet today for the fourth International Fair Trial Day, and the focus country this year is, of course, the Philippines. Today's program brings together experts and commentators from all around the Philippines and elsewhere who have detailed knowledge of the challenges to fair trial rights in the Philippines. And this opening panel is here to set the scene for the day and welcome our keynote speaker, George Katrakalis, the UN independent expert on the promotion of a democratic and equitable international order. But before we hear from George, I'd like to introduce you to our other three speakers who will make brief opening remarks. And perhaps I could invite them all to come up and sit on the sofa here with me before we start. So that's Attorney Jose Lolita, Darlene Berbera, Dean of the College of Law, and Ebru Olalia. Perhaps I could invite you, Jose, to take the floor. Jose is the National Executive Director of the Integrated Bar of the Philippines and will make a few opening remarks. Thank you.
Thank you very much. First of all, I must convey the apologies of our national president, Attorney Pido. Unfortunately, he could not be here today because they have a Board of Governors meeting in Panglao, Bohol. So I have to stand in for him today. May I greet a good morning to retired Justice Adolfo Ascuna, my former professor and dean, Pacifico Agabin, the Chancellor of UP Diliman, the Dean of the UP College of Law, colleagues, friends, fellow workers in the law, good morning. It is a pleasure and an honor to welcome you all today to the International Fair Trial Day and for the conferment of the award, which was named after a Turkish lawyer who passed away in protest to not having a fair trial. So it is indeed fitting that such an award will be given in her name. The Integrated Bar of the Philippines is very pleased to co-sponsor this event because, as we all know, all of us lawyers, whether in the Philippines or the distinguished lawyers here from all over the world who are with us today, all of us need to have fair trial. All of us need to have the rule of law, because without the rule of law, there can be no room for lawyers. So again, thank you very much. Welcome and good morning.
Thank you. And next, I'd like to welcome Ebru Olalia, the chairperson of the National Union of People's Lawyers.
Good morning. I will dispense with the felicitations. I'll go straight ahead with my prepared text for time. Today seems to be a sad day, for the International Fair Trial Day Steering Group has unfortunately chosen us as the focal country this year, quote, due to systemic problems with the independence of the judiciary, serious human rights violations against lawyers and human rights defenders, a culture of impunity, and a failure to respect procedural rights for a fair trial, close quote. It is not a cause for celebration nor pride. But what kind of nation did our visitors come to? It is a place of contrasts, contradictions, and conflicts in society, with the challenges of human rights defenders and the dangers of people's lawyering, but where there is nonetheless compassion, conviction, and commitment to change things for the better. It is a country that commemorated independence a few days ago, but with foreign boots on the ground all over the place. It is where the poor farmers do not even own the land they have tilled for generations. It is where the huge labor force cannot find work and where millions of migrant workers slave it out in other countries to be able to have a vacation back in our own country. It is where we see legions of doctors, but the majority of the population do not have basic health care. It is where the minute elite live up while the shoeless and shirtless die of hunger and sickness, let alone gunned down in the streets like animals. It is a place where they say we have one of the freest press in the world, and yet journalists are slapped with harassment suits if not killed. It is a place where they say democracy thrives, but dissent is silenced in so many ways and means. It is where human rights defenders are red tagged and need to defend themselves and their own human rights. And it is where the so-called rule of law is often eclipsed by the rule of force. It is a place where lawyers abound and hundreds more added every single year, but justice is inaccessible to many. It is where we have nice laws against torture, against disappearances, and on the rise of the accused, as well as the protective judicial remedies, but violations seem to be standard operating procedure. And it is a country where there are draconian anti-terror laws, but the real terrorists and terrorist financiers are out there and not in jail. It is a place where lawyers, judges, and prosecutors under siege cannot get decisive protection, much less justice themselves. It is where the government keeps on boasting that we have a robust justice system and that domestic remedies are, after all here. Really? But from the perspective of the victims, what is wrong with the justice system in the Philippines? Apart from subsisting jurisprudence and laws and legal hocus-pocus and shortcuts that do not align with the principles of a fair trial, allow me to quote from the verdict of the International People's Tribunal held last month in Brussels, and I quote, "A recurring fact and common denominator is the continuing lack of genuine accountability, brazen impunity, and proven general ineffectiveness and inadequacy of the basic remedies that by and large prevent or fail to give justice to the victims. Reprisals or threats of reprisals and intimidation of the victims, relatives, and witnesses, both physical and legal, through harassment suits and weaponization of the law, lack of trust and frustration in the legal and judicial system, and of course, preoccupation with survival and constraints of earning a living hamper prosecution. There is sloppy, testimony-dependent, unscientific, token, and even lack or absence of competent and genuine police investigation, even passing off the blame, or what we call false flag tactics against victims. The justice system remains very slow, protracted, with all due respect to my colleagues, tedious, complicated, cumbersome, and expensive, or inaccessible. Legal technicalities like the presumption of regularity in the performance of official duties, circumvention or even outright dismissal of application for protective remedies, and non-observance of the few human rights laws have been obstacles. These are aggravated by endemic corruption and use of connections, influence, power by perpetrators, fear and lack of independence of some prosecutors and judges, and double standard between the rich and powerful and the poor. Worse, there is coddling, rewarding, and tolerance by the political leadership or perpetrators. Ultimately, there seems to be lack of a political will on the part of authorities to pursue cases against perpetrators, close quote. And this is the part where groups like the IFTD can come in. It is an opportunity to turn a bad thing into a good thing. With your visit and presence, this, after all, is not really a sad day, but a cause for challenge and hope as you aim to raise awareness about the importance of respect for fair trial rights. Today's event is another welcome initiative to draw attention to the situation in my country, in our country, as we wrap our heads around concrete recommendations rather for reform. So, on this fair trial day, we warmly welcome and embrace you in solidarity and hope that you can come back, not for the reasons you are here now, and not under circumstances of lawyering dangerously. We look forward to the day when things would become better even before they get worse. Thank you very much.
Thank you very much, Edre. And just before I introduce the next speaker, I just should mention that today's events are being recorded, as you've probably realized from the cameras at the back of the room. And finally, I'd like to invite Darlene Berberabe, the Dean of the College of Law here at the University of the Philippines. Thank you.
Thank you very much, Tony. Ka Edre, may I be given the privilege to greet, because we are the host, as the venue host for today's event. May I please greet some people who are in the audience: Chancellor Edgardo Carlo Vistan, Justice Adolf Ascuna, our Dean Pacifico Agabin, Congressman Neri Colmenares, classmate, Congressman Satur Ocampo, magandang umaga po. Of course, Ka Edre Olalia, thank you for that impassioned and inspiring opening message. The Director of Institute of Human Rights, Professor Elizabeth Giling Pangalangan. Of course, our Director of Office of Legal Aid, Professor Ted Te, my professor, Secretary Judy Tagiwalo, of course, Dean Juju Lotilia, and to the speakers, distinguished guests, esteemed colleagues, honored awardees, friends, ladies and gentlemen. So when I was listening to the speech, to the opening message of Ka Edre, I became very sad, okay, at first. But because today is my birthday, thank you very much, I refuse to be sad. And so the sadness became a lot of hope in the last message, and that was also the thought that I was having when I was hearing the things that, or the reasons that we should be sad about our country. But every birthday signifies hope, and the reasons that brought all of us here, as long as we have leaders like you, as long as we have citizens who are given the space and the freedom to share their ideas, and as long as we have a venue like this where we can share our ideas and continue to push and continue to share our passion and energy, I think is a very good reason to be hopeful and to be positive. Today, I was asked to be a commencement speaker in some graduation. I said, no, I don't want to work that hard on my birthday. But when Attorney Ephraim, Rina, and Attorney Josa went to the office of the Dean and told me, can UP be the venue? I asked, when is that? June 14. So I just said no to the commencement speech, but I did not have any second thoughts. I said, thank you for the honor of hosting this event. So good morning and welcome to the International Fair Trial Day Conference and the Ebru Timtik Award Ceremony. It is an honor for the UP College of Law to host this event here at the University of the Philippines. Today, we are gathered with local and international stakeholders and experts, including victims of violations on fair trials, to deliberate on principles of justice and the rule of law. This conference shall serve as a testament of our shared obligation to protect human rights by ensuring that everyone gets a fair trial, no matter who they are or where they come from, and that no innocent man gets punished. Moreover, it intends to raise awareness on human rights concerns such as extrajudicial killings, torture, and ill treatment, as well as the abuse or misuse of counterterrorism measures against lawyers and human rights defenders. Ebru Timtik was a symbol of resilience and an advocate for justice whose legacy we celebrate here today. She was not just a lawyer, she was a crusader for justice. Her life and death mirror the struggles within the legal profession and within the society at large, emphasizing the need for the protection of lawyers and human rights defenders and the importance of a fair justice system. Her dedication is a wake-up call to safeguard fundamental rights and to ensure that the rule of law prevails over tyranny and oppression. As legal practitioners, advocates, and as ordinary citizens, we are reminded of our obligation towards lending our voices to the voiceless and to ensure that human rights are given importance globally. I would like to take this opportunity to thank the organizers, speakers, and participants who have contributed towards making this conference possible, particularly the IFTD Steering Group, the UP College of Law, including its Institute of Human Rights and Office of Legal Aid, the National Union of People's Lawyers, and the Integrated Bar of the Philippines. In honor of Ebru Timtik, may this conference urge us to commit ourselves to the noble cause of justice for all. Thank you, and once again, welcome.
Thank you very much, Darlene, and happy birthday from all of us. And thank you for coming to speak on your birthday. So it's now my great pleasure to call George Katragoulas to the stage to make his remarks as UN expert on the promotion of a democratic and equitable democratic order. Thank you.
Good morning, ladies and gentlemen, and happy birthday, dear colleague. I'm very glad to be among you, dear colleagues at the bar and at the university. I'm a constitutional law professor, but I have defended also many cases of public litigation. And I must tell you also that I easily connect with the history of your country. Ancient Greece is the cradle of democracy, but modern Greece is a different story. Not only we have never been colonizers, we have been under foreign occupation for 400 years. We had two dictatorships. We had, in our 200 years of modern Greece, one civil war. So many occasions for brave lawyers to defend those without voice, innocent victims of political persecution, and also, of course, democracy. I am also especially glad, and I would like to thank the organizers, because this is my first international event as a United Nations expert. My mandate started just last month, 1st of May. What are these so-called special procedures of the United Nations? There are experts, independent experts, selected by not political procedure, with expertise either in thematic areas. We have an international rapporteur on the right to assembly, one rapporteur on social rights, and so on. Or in countries. We have a very pertinent and very active special rapporteur on Palestine, on Iraq, on Cambodia. My mandate is on a democratic and equitable international order. The main focus of the mandate is about democracy and human rights at the level of the international organizations. But there is not a watertight division between international and national levels. I understand my mandate to extend in democracy and human rights, both at the national and at the national domestic level. And I believe that a basic component of it is also justice. Equal rights and self-determination of people, democracy, justice, equality, the rule of law, pluralism, development. One cannot separate one from another. The Vienna Declaration of 1993 taught us exactly that all human rights are indivisible, and they are not inferior human rights, like the social rights, which deserve to be honored and protected, like the traditional political rights and freedoms. And why do we need a mandate, a special procedure on democracy at international level? But exactly because there are tremendous global asymmetries, as in the farm of the island, the farm of the animals. All states are equal, but some states are more equal than others. And we have many cases of double standards, not just regarding international governance, but also regarding justice. I'm going to read a small excerpt of a concurring opinion of a judge at the European Court of Human Rights in a case concerning the killing of some Iraqi civilians during the occupation of Iraq by the international forces. The judge, Judge Bonanno from Malta, says, quote, "I am unwilling to endorse a la carte respect of human rights. I think poorly of an esteem of human rights that turns casual and approximate depending on geographical coordinates. In substance, the UK was the litigant in this case, is arguing, sadly, that is ratified the Convention of Human Rights with deliberate intent of regulating the contact of the armed forces according to latitude. Gentlemen at home, hoodlums elsewhere." Unquote. He says that the judge, because in this case, UK has claimed that implementing the European Convention of Human Rights abroad would have amounted to human rights imperialism, as if there are not other cases of imperialism, much more palpable. Another great challenge for human rights and democracy, both at domestic and international level, is of course globalization and the polycrisis, this confluence of crises we have the last years. The compounding effect of this polycrisis, the confluence of economic, pandemic, climate crisis, global conflicts, and especially rising inequalities, have reversed the global progress on development and poverty reduction. It is the first year after the pandemic that the Human Development Index, the index established by the United Nations to measure how good our countries are scoring, is for the first time in decline. 9 out of 10 countries are globally registering a backslide in health, education, standard of living. The number of people living in extreme poverty, which had markedly fallen for almost 25 years, is now on the rise. A projected 575 million people will still be living in extreme poverty, and only 1/3 of the countries will have halved their national poverty levels by 2030, when was the goal of the Sustainable Development put by the United Nations. And the rise of inequalities is another symptom of this polycrisis. The United Nations General Secretary recently called for the survival of the planet and humanity, and he decried that the 26, note that well, just 26 richest people in the world hold as much wealth as half the global population. The 1% of the world's wealthiest captures 27% of the total cumulative growth in the last 4 decades. And another danger in many countries in this period is what we call securitizing human rights. That is, introducing a quasi-permanent state of exception in the name of combating terrorism, which amounts to practically putting in brackets the protection of human rights. How are people globally understanding these processes? I'm going to refer shortly on some global surveys that show that there is a global support of human rights. To the statement, human rights reflect values that I believe. 70% of the median global average agree. But again, there is a widespread perception that human rights are applied selectively at the global level. When asked if human rights, I quote the question, are used by Western countries to punish developing countries, unquote, a plurality agrees with a global average of 42%. Even in the United States, respondents were more likely to agree, 34%, than disagree, 28%. At the national level, most people want their government to focus more on justice, corruption, and poverty reduction. A global median of 41% globally consider poverty and hunger as the world's top challenge at the international level. For many years in a row, economic inequality is also perceived to be the #1 threat to global democracy by 68% of the respondents, followed by corruption, 67%, and the influence of global corporations, 60%. Again, there is a generalized mistrust towards governments. A global majority of 48% of people said in 2024 that their government mainly serves the interest of a minority. This sentiment is more prevalent in the Latin American countries, in the United States, and in Europe. What is the response that we can give to a situation like that? How we can defend democracy and human rights? An important step forward is, of course, the united system of protection of rights and the international order based on rules. It is true that the United Nations have been established by an initial agreement of the 3 great winners of the Second World War: United States, Soviet Union, United Kingdom. But during the deliberations, both for the UN Charter and the Universal Declaration of Human Rights, the Global South has participated and in many cases has changed the route of the discussions. Philippines, for instance, had a great participation in these discussions. To give just an example, when it was discussed the Article 5 of the Ecumenic Declaration, or Universal Declaration, prohibiting torture, the Philippine Republic objected to a proposal to insert provisions for cultural differences. The Philippine delegate argued that with such a provision in place, Nazis might have claimed that their torture chambers were customary and therefore legal in Nazi Germany. And what about a fair trial? What about the system of justice? It is estimated that 5.1 billion people around the world, that is the 2/3 of the population on Earth, lack any meaningful access to justice. This estimate includes communities that cannot resolve everyday justice problems, people left out of the protection of the law because of poverty or of exclusion, and people who live in extreme conditions of injustice, like modern slavery or trafficking situations. Even in Europe, we have cases of European Court of Human Rights regarding modern slavery. And the right to a fair trial and justice has an absolute minimum core. For having an impartial justice, we need efficient guarantees for the personal and factional independence of judges, insulated from political or corporate influence. This is the minimum institutional prerequisite, but it is not enough by itself. In an important case of the European Court of Human Rights, the Eyre case, the court has concluded that if there is not a legal aid system, we cannot have a fair trial. And this without having a clause like the one you have in your constitution, in the European Court of Human Rights. The court said, I quote, that although the convention does not concern by itself social and economic rights, this is not to be a decisive factor against an interpretation obliging the states to have a legal aid. There is no watertight division separating that sphere from the field covered by the convention. And as one of your people's lawyer, Romeo Kapulong, has constantly remarked, legal aid by itself is not enough. Legal aid should be combined with public interest litigation. As he says, I quote, if we fail to raise the beneficiaries' awareness of the social and economic inequities, legal aid diminishes rather than helps the poor by perpetuating poverty and injustice. Your Chief Justice, Renato Puno, has remarked something that does not concern all your country, is almost a universal standard. I quote, the playing field in the justice system is often against the poor. So we have an obligation to defend the voiceless, the defenseless, the excluded. And by defending themselves, we defend the ideal of justice and ultimately democracy itself. This is the role of human rights defenders. The year 2023 marked the 25th anniversary of the United Nations Declaration on Human Rights Defenders. According to this international treaty, everyone is entitled, individually and in association with others, to be protected effectively under national law in reacting against or opposing through peaceful means activities and acts attributable to states that result in violation of human rights and fundamental freedoms. Basically, it's about the fight against impunity, against any lack of accountability. One of the activists at a forum of the United Nations for the defenders Cesar Siva, who worked with others in bringing military personnel to justice for abductions, disappearances, extrajudicial killings, torture in Argentina, has said, I quote, "They tried to make the horrors invisible. They all kept silent, and with it they tried to cover up the magnitude of what they have done. Little by little, we put words to these events." This is our task, helping people, especially the weak, the vulnerable, and the oppressed. As the song goes, the broken, the beaten, and the damned. Holding both governments and big businesses accountable. There is an obvious interplay between the economic policies, human rights, and good governance. And we must also try to ensure effective public participation of affected communities. Human rights defenders have secured striking victories for their communities in the face of state authoritarianism, police brutality, and environmental degradation. We must never forgive that climate crisis is a challenge for the survival of the planet, not just for our well-being. And rights defenders are often most at risk of being killed. I conclude with some, let's say, conclusions or recommendations, but just first thoughts about this major problem. First of all, that commitment to democracy and equality is an essential component of the struggle to justice and equity. Secondly, solidarity is important. Most human rights defenders report that their success depends on support from local, regional, international networks, especially regarding combating acts of reprisal. Third, that promoting public participation in decision-making is important. We must never understand our role as the savior of the people. A Greek author says that salvation is good business only for the savior, never for the victim. Our ultimate duty is to help people understand the deep root causes of their problems and get self-organized to struggle for justice and social change. The United System of Rights and its special procedures are right to help you in this direction. You can contact us, liaise with my mandate and others, referring injustices or pointing to issues that you want us to raise and investigate. We have 2 annual reports that are voted by the General Assembly and the Human Rights Council. We can address the governments and ask in explanation regarding violation of human rights, and we can try also to make them accountable through official United Nations procedures. And my last remark, it may be the most important. Always remember what the Romans said about the human rights. Jura sunt vigilantibus scripta. Jura sunt vigilantibus scripta. The rights exist only if we are vigilant for their protection. Many thanks for your attention.
And thank you very much, George. And that concludes the opening session. And I'd now like to hand over to Eleonora Scala, who will facilitate the session on the independence and protection of judges and lawyers.
I invite the panelists to come on stage as well for session 1. Cruz, you can sit on the chair. Yes. So you can follow the PowerPoint. No, let's present from the... Just take a microphone, yeah. Good morning, everyone, and welcome to the distinguished panelists here on stage, Professor Te, Judge Rico Cruz, and Attorney Ray. It is an honor for me to moderate the first of 4 thematic panels that we will have throughout the day. My name is Eleonora Scala. I am an Italian lawyer working in London for the International Bar Association's Human Rights Institute, where we focus on many human rights projects at global level, one of which is this yearly initiative of the International Fair Trial Day and the Ebru Timtik Award. And many months ago, as we were having one of our recurring Zoom meetings to organize today's conference, we had as an agenda item for discussion how to structure this conference, all the panels throughout the day, which topic to focus on. And I have to say, it was probably one of the smoothest and quickest decisions that we were able all to agree on, the need to start this conference with a discussion on what we all understood to be the bedrock of any fair trial, namely the independence of the judiciary and the independence of the legal profession. And so it is on these fundamental principles that this first panel will delve on. These principles that are so crucial for an administration of justice that serves its purpose. And our panelists will address the threats and challenges to the independence of the bench and the bar, but also explore strategies to uphold and strengthen this cornerstone of fair trials. And in this context, also the risks to the safety and the lives of the legal professionals in the country will be touched upon. And in light of the killing just this Monday of prosecutor Eleanor de la Peña, we would like to think that in our little way, having this discussion is also a way to honor her life, her work, her commitment to justice. And in terms of structure of the panel, we will have an initial discussion between the 3 panelists here, and there will be a separate section when a representative from a fact-finding mission that just ended its activities will give some background on the mission, and we will also have the screening of the teaser of a documentary on the fact-finding mission, but we'll tell you more about it shortly. So to start with Judge Rico Cruz, she's currently the presiding judge of the trial court of San Fabian San Jacinto in the province of Pangasinan. And I bet she must feel at home here at the UP College of Law, because this is where she completed her legal studies, but she also served in different capacities here with the Office of Legal Affairs, the Office of Legal Aid, and she also had some teaching commitments, teaching assignments here. For the Integrated Bar of the Philippines, she served for the Commission on Bar Discipline when she investigated disciplinary cases against lawyers. And among other roles and professional affiliations, she is also treasurer and member of the Board of Trustees of HUCOM, an organization of justice that advocate for judicial independence and educational opportunities to enhance the competencies of judges. So, Judge Rico Cruz, please tell us a bit about the status of judicial independence in the Philippines from your unique insider perspective.
All right. Thank you, Eleanor, and good morning to everyone. Okay, so I'm here to speak about judicial independence. What is the status of judicial independence here in the Philippines? And I think I was invited because, well, as an insider, being inside of the judiciary, maybe I'm in a better position to talk about it. Now, I prepared a slideshow presentation just to show everybody the many facets of judicial independence here in the Philippines. Of course, for our Filipino participants, especially if there are law students here who are with us today, I think the concept of judicial independence is fairly easy to grasp. But for our friends from different jurisdictions, I think it would be good if I could present a background to you of how we handle or how we have conceptualized judicial independence here in the Philippines. Well, I think needless to say, judicial independence is really the bedrock of the work that we do here in the judiciary, because if we are not independent, okay, I don't think we will be able to decide cases fairly, only looking at the evidence and not being pressured by both external and internal factors. However, the concept of judicial independence is not really that simple. It's not all about external pressures to the judiciary, because there are some institutional factors that we also have to take into consideration, particularly even constitutional and legal provisions that might affect our independence. Right? Now, with regard to independence, our constitution, the 1987 constitution, which is what is prevailing now here in the Philippines, it's very specific there that one of the qualifications of a member of the judiciary, from the Supreme Court up to the trial court judges like myself, is that we should have competence, integrity, probity, and independence. The 1987 Constitution, particularly paragraph 3, section 7 of Article 8, okay, exhorts that we should be persons of independence before we can qualify as judges. Now, as to whether or not that's true, that's another story altogether. But I would like to discuss now the institutional situations that we face. All right. Now, we do, aside from the Constitution, we do have a code of ethics for judges here in the Philippines. And in fact, we've already had 3 codes of judicial conduct. The first one was way back in 1946. And this was proposed by the Philippine Bar Association. Okay, it's fairly short code of judicial conduct. And then it was revised in 1989. It contains 5 canons with 32 provisions. The 1989 Code of Judicial Conduct was the one I studied when I was still in law school. Okay, and then in 2004, next slide, please. Yeah, all right. In 2004, right, we formulated the new Code of Judicial Conduct for the Philippine judiciary. This is in keeping with our commitments to the United Nations when they initiated the so-called Bangalore Draft, right? The goal being to have a universal code of conduct for judges, which means that this code of conduct that we are following, this is something that you should find in every country. Okay? Precisely because this is the product of a conference among nations wherein we have all agreed that we should have a universal standard when it comes to the behavior of judges. And in the Bangalore draft, during the time that that particular code of ethics was being drafted, the representative of the Philippines at that time was Chief Justice Hilario Davide. So in adopting the Bangalore draft, we now came up with the new Code of Judicial Conduct for the Philippine judiciary in 2004. Now I understand that the Supreme Court is in the process again of revising or amending this code of conduct to include now the behavior of judges on social media. Okay, we have to keep up. I mean, technology is running faster than any of us could run. So the Supreme Court is already in the process of doing that, and we are expecting the new draft probably in the next 2 years to include particularly the behavior of judges on social media. All right, now, why is, next slide please. All right, now when it comes to the concept of judicial independence, there is some sort of an evolution among the 3 codes of conduct that we have so far, right? In the first canon of judicial ethics, the 1946 set, there's only one canon. Okay, it simply says a judge should not be swayed by public claim or personal popularity. That's how judicial independence was crafted under the oldest code of conduct that we had. And then in the second code of conduct in 1989, we now have three aspects of judicial independence, which is, well, this is basically what we do as judges. We have to be impartial, we have to be of integrity, we have to know what our job is and not be pressured by external factors. Now, in the new code of judicial conduct, next slide please. Okay, now, there are several innovations that were introduced by the Code of Judicial Conduct. But this is the first time that our Code of Conduct mentions the executive and legislative department when it comes to judicial independence. And I will show that to you, number 5. It says there, and I quote, "Judges shall not only be free from inappropriate connections with and influenced by the executive and legislative branches of government, but must also appear to be free therefrom to a reasonable observer." Okay? For the first time, the executive and the legislative branches were mentioned, were explicitly mentioned in our Code of Conduct. All right? So why? Why do we think that they were explicitly mentioned? Well, we all know that already, all right? So, well, it is unfortunate that there are judges who are pressured by politicians. Okay, politicians throw their weight around trying to influence cases that are being decided by our courts, unfortunately. Now, whether or not judges cave in to such pressure, I would like to believe that majority of judges still hold their ground, and we do not allow political pressures when it comes to deciding our cases, right? So, but this is the first time that it is explicitly mentioned. However, this is the part where I discuss now the institutional challenge. Next slide, please. Okay. Under Section 9, Article 8 of the Constitution, we are presidential appointees, all right? From the Supreme Court, from the Chief Justice of the Supreme Court, up to the first level judges like myself, we are presidential appointees, all right? But we are not coterminous with the presidents who appoint us, right? We serve until our compulsory retirement at age 70, all right? We are the only public official in the Philippines wherein the mandatory age of retirement is 70 years old. Others retire at 60. So I guess they expect us to live longer than everybody else, all right? That's why that is our compulsory age of retirement, all right? But we are presidential appointees. And Professor Teddy Te will discuss later the manner of selection of judges from the JBC up to the appointment. But of course, let us be honest. Like I said, it's difficult to, this has always been my stand, it is difficult to confront a problem and look for solutions to it if we are not honest about what the problem really is. Okay? The fact that we are presidential appointees, I think you all know where this is going, right? I mean, we are shortlisted. We go through the Judicial and Bar Council. We present our credentials to them. We are shortlisted for the positions that we are applying. And then the shortlist will be given to the president. Okay? The president has absolute discretion as to who he or she wants to appoint. All right? So even if, for example, the Judicial and Bar Council gives a list, okay, and then they also give our resume, okay, no matter how qualified you are or how more qualified you are than the other candidates, it is still the discretion of the president as to who he or she will appoint as judge. All right? So that alone is already, I don't want to call it problematic, but then it is problematic, all right, if you're going. And there are so many, there are moves now to amend the Constitution of the Philippines for specifically the economic provisions. However, if you're going to ask me personally, if I am to amend the Constitution, this is the only provision that I want taken out from the Constitution. Okay? So, judge, if you don't like the president appointing judges, how do we have judges now, all right? Well, if I may, I would like to make appointment of judges a purely academic exercise. Meaning, judges will have to go through the entire academic process again, study, pass an examination of some sort, and then become judges. I think, do we have friends from Spain? I think that's how they do it in Spain, right? It's a purely academic exercise. If that is the case, right, if we would make it as a purely academic exercise, then we are more assured of independence. Anyway, in our Constitution, for those of you who are studying constitutional law, okay, the members of the judiciary are the only ones who have academic qualifications under the Constitution, okay? Because in order for you to become a judge, you have to be a member of the bar first. If you have to be a member of the bar, you have to pass the bar examinations. To take the bar, you have to be a graduate of law. To be a graduate of law, you have to be a graduate of some other degree before. So really, we're the only ones who have that academic qualifications under the Constitution. So if that is the case, why not make the appointment process for judges a purely academic exercise? Okay? But wait, I'm dreaming. So next slide, please. I'm dreaming. Okay. All right. Okay. This is the more controversial aspect of the judicial independence problem. All right. Under the Local Government Code of 1991, Republic Act 7160, all right, local government officials like governors, mayors, okay, if their budget allows it, they may give judges allowances. All right. It is allowed under the law. The only caveat is that they should have available funds in order to give allowances to judges. And not only judges, prosecutors, public school teachers. All right? Of course, we all know where this is going, correct? Okay. Originally, all right, in fairness to the drafters of RA 7160, the original intention really was to augment the budget of courts, right? So we are giving you allowances. Okay, I'm the mayor. I'm giving you, judge, your allowance. Hopefully, you can use it to augment the budget of your office. So for example, you suddenly run out of bond paper, computer, ink, and stuff. This is something that you can use. Unfortunately, and I really regret to say this, there are judges who took advantage of this provision to ask for allowances from local government officials when there is none, or to ask for increase in allowances from local government officials. On the flip side of it, politicians also took advantage of this provision to have some kind of influence or clout over judges. Okay? And that is easily understandable. I mean, if I'm the mayor, I'm giving the judges certain allowances. Well, you know where, of course, I would have some proprietary stake on that judge. And believe me, there are, especially here in NCR, the allowances are really substantial. I understand, if I am not mistaken, Taguig City gives the biggest allowances to judges. Each judge receives 50,000 pesos a month by way of allowance. In dollars, that would be roughly $1,000, $1,000. And they're the biggest. Okay? So now, the question is, what if the judge is receiving 50,000 pesos from the mayor? I don't know. Okay? In my case, in San Fabian, I do not have an allowance. And I never lobbied to get one. Okay? For me, it's not necessary. All right? They don't have to give me any because I'm properly compensated under our system of salaries for government officials. So, not needed. All right? Next slide, please. Thank you very much. Next slide, please. All right.
Judge Rico Cruz, maybe before we move to the case law, we continue for the discussion
Yes,
from
of course.
I wanted to bring in also the perspective of practitioners from the bar, so maybe we can continue in this direction, and then if we have time, we dive into the case
all right.
studies. Yes, no, thank you very much for your insights on the institutional problems at constitutional and codes of judicial conduct and also local government legislation level. I think we will also continue discussing the problems with the appointment throughout the panel. I would like now to pass it on to Attorney Ray. Attorney Ray is the current president of NUPL. He's actively involved in cases to counter political repression, violation of human rights and civil liberties. He appeared orally before the Supreme Court as counsel questioning the constitutionality of the anti-terror law, of the declaration of martial law in Mindanao, and against the burial of the former dictator Ferdinand Marcos at the National Heroes Cemetery. He also represented for many years the Philippines at the session before the United Nations Human Rights Council in Geneva. So, Attorney Ray, please give us a perspective from the bar.
Yes, my dear colleagues and friends, good morning. I will discuss this morning the impact of judicial independence, or the lack of it, on the right to a fair trial. The last speaker, our colleague from the Netherlands, Hans Gijsbeek, will give us a background on their mission regarding the attacks on lawyers, which will complete the picture on the state of the independence of judges and lawyers in the Philippines. Judicial independence is a relevant issue in the Philippines, and this is in the light of the weaponization of the law against those who exercise their right to dissent. Judicial independence, or the lack of it, is crucial to the right to a fair trial. The present administration continued the practice of filing trump-up charges against advocates and personalities associated with political and sectoral organizations which they labeled as Communist Front organizations. This became more prevalent after the creation of the National Task Force to End All Local Communist Armed Conflict, which became primarily responsible in initiating legal offensive against such organizations and their leaders. The weaponization of the law is obviously systematic and state-sponsored, and we see the entire structures of government working in unison to make it effective. Unfortunately, based on our experiences, agencies that were supposed to dispense justice are themselves part of this scheme to perpetuate legal harassments. The Philippine judicial process involved many actors in its different stages. First, we have the investigation stage, at which facts are determined for the purpose of filing cases. This is performed by the police and other investigative agencies of the government, like the National Bureau of Investigation. The preliminary investigation stage, where the facts or the evidence gathered by the police are presented for the determination of probable cause to indict the perpetrators. The third is the prosecution stage, where the alleged perpetrators are prosecuted. For trump-up or contrived charges to prosper, the main actors in all these stages must connive in order for a false charge to survive scrutiny. One of the primary observations as regards investigative competency of our law enforcement agencies is that they seem to be incompetent or even negligent and very slow when they investigate extrajudicial killings involving activists, advocates, and dissenters. In many cases, there are apparent lack of effort to identify, investigate, and prosecute the perpetrators. Take the case of a couple, 2 of the 9 activists killed during the Bloody Sunday Massacre in March of 2021. Their child saw them being dragged out of their house, shot and killed by soldiers. But the panel of prosecutors that investigated the case was not convinced by the evidence, despite an eyewitness account, and dismissed the case for insufficiency of evidence. We take note of the increasing numbers of cases involving terrorism and financing terrorism against activists and advocates. These cases are based on the flimsiest of grounds. At the center of all this are the alleged rebel returnees, many of whom were placed under the social integration program of the government and are under military custody. They provide the alleged evidence against targeted activists and advocates. These rebel returnees have superhuman attributes because they can see in the dark, identify the persons who allegedly ambushed a military unit, and recite the true names and aliases of tens and sometimes even hundreds of implicated individuals. At a glance, you can easily decipher the incredulity of the accusation as well as the evidence presented. But this evidence surprisingly survived scrutiny by the prosecution service, who often than not recommends the filing of indictment against the respondents. And as I glance at the audience, I see many victims who are present today of this modus. These contrived cases cannot possibly pass through and survive preliminary investigation. Undoubtedly, the cooperation of both the law enforcement agencies, including the military, and that of the prosecution service is essential for a trumped-up charge to survive this stage. Even the courts are not insulated from this scheme. Knowingly or unknowingly, they also become the instruments for the perpetuation of legal harassments. Under our rules of procedures, even if a case passes through preliminary investigation, there are available remedies when the case reaches the court. These remedies are supposed to to ensure that only the guilty are to be prosecuted. These remedies are defunct and useless when it comes to cases involving dissenters and advocates and political prisoners. And the courts usually, except in few instances, rule that the accused is merely delaying the proceedings and that the grounds are mere matters for defense. In other words, in many of our cases involving these cases, there were opportunities at the initial stages of the case for the courts to dismiss them through the above-cited remedies. But they do not, and instead allow the cases to go through a full-blown trial, seemingly unmindful of the Supreme Court's admonition in Salonga versus Cruz-Paño and re-echoed in subsequent cases when it ruled that, and I quote, "It is therefore imperative upon the fiscals or the judge, as the case may be, to relieve the accused from the pain of going through a trial once it is ascertained that the evidence is insufficient to sustain a prima facie case or that no probable cause exists to form a sufficient belief as to the guilt of the accused." End of quote. In the light of the passage and the implementation of the anti-terror law and the anti-financing terrorism laws, this kind of setup is quite troubling for our clients, who are advocates and activists, the same segments who are the designated target for terrorist or financing terrorism prosecution. The problem is the state is using the same modus, the use of the perjured testimonies of alleged rebel returnees. What makes it more difficult is that terrorism and financing terrorism cases are heard and tried by the designated anti-terror courts. designating specific courts as anti-terror courts make them vulnerable to pressures from state forces. Because you need not speculate where these cases are to be filed and tried. How can we forget how they vilified the judge who quashed the search warrants issued against 2 activists, or the judge who dismissed the proscription case against the Communist Party of the Philippines and the New People's Army, or the presiding judge who issued defective search warrants after she met with a high-ranking police officer. To summarize, trap-up charges cannot possibly commence if the filing of the complaint is not initiated by either the police or the military using manufactured evidence and perjured witnesses. It cannot be filed in court if it is not approved by the investigating prosecutors. The case can only pass through pre-arraignment and pre-trial remedies if the court will allow it. Under these circumstances, we cannot possibly obtain justice from our courts. The blindfolded Lady Justice, which symbolizes our justice system, aptly describe our predicament and the inadequacy of the legal and judicial system in our country. Because of our blindfold, the Lady Justice is unable to see the exploitation, the repression, and the injustices around us. Thank you and good morning.
Thank you very much, Attorney Ray, for reminding us of the importance of fair trial guarantees of the accused when human rights are on the line, and in these trumped-up charges cases, the way in which the judicial system can be abused. And it would be interesting now to hear further reflections on what the previous 2 speakers brought to this panel from our 3rd speaker, Professor Ted Te, that today comes to this panel wearing 3 hats. He has the academic hat on because he's an assistant professor here at the University of the Philippines, but also a very big practitioner hat. He's the director of the Legal Aid Office here, but also a long-standing human rights lawyers with the Free Legal Assistance Group. And he also has a hat linked to the judiciary, as he's been a communication officer for the Supreme Court for 5 years. And his engagement with the judiciary continues through the Philippine Judicial Academy, the training academy for judges. So, Professor, please give us your tridimensional insights on the issues that we've been discussing.
Thank you. If you allow me, I'll just speak from here. Okay, you can't have independence if you cannot imagine or think differently or speak out openly or dissent without fear of sanctions or being treated differently. That's easy to understand from an advocate's point of view, from an ordinary person's point of view, but may not be very easy to understand from the point of view of a judge, because the traditional view of a judge or a court is that it is a passive receptor, and the word that is often used to describe a judge is impartial, not independent. And so we need to look at how independence is defined from the point of view of the judiciary. And I'd like to just touch on very quickly 6 very short points. First, appointments. Judge Rico Cruz here mentioned that the appointments are done exclusively and solely by the president. That is the setup. That is the constitutional architecture. And it brings its share of problems in terms of independence. Yes, there is a judicial and bar council that is supposed to do the vetting. And the vetting is for all judges. So you can imagine from the first level up to the Supreme Court. You can imagine the amount of time it takes. And so you can also imagine the amount of delay it takes to appoint a judge. And as if there are vacancies in courts, then you leave open the possibility of influence or pressure. And you leave open the possibility of people who would lobby for appointments. and not just the interested judges themselves, but those who would be interested in getting those judges appointed. So I agree that there must be a better way of appointing judges. There must be a better way of filling up court vacancies. There must be a less politically influenced way of getting judges appointed, because it reduces the level of dependence on the appointing power and the need for judges to basically lobby for appointments. Second, judicial education. I am with the Philippine Judicial Academy, and I am very happy to say that there have been a lot of changes in the last how many years in terms of judicial education. And I think this is important because judges must do more than just apply what the Supreme Court rules. Judges must be able to think on their own. That's how we can call them judicially independent. They must be able and they must be unafraid to advance a legal theory that addresses justice rather than law. But if they fear that they will not be promoted, if they fear they will be reversed by the Supreme Court at the first level, and then that now leads to a culture of kicking the can forward, right? And so many of the practitioners here will know that that is the usual situation we face. Judges may be sympathetic to our clients at the first instance, but they know that ultimately this will go to the Supreme Court. And so they will just wait. And if they have the desire to be promoted, then they will wait. And they will just not risk being overturned by the Supreme Court. So, yes, judicial education must get judges to a point where they are unafraid to advance a legal theory that is more consistent with rights and justice rather than just simply applying the law. We are getting there, but we are not yet there. The curriculum of the Philippine Judicial Academy is being continuously reviewed and revised, and hopefully we can get to a point where we can train judges, especially at the first and second level courts, to be able to advance judicial and legal theories that are more consistent with protection of rights rather than just simply applying the law. Because you will learn that, judges will learn that just by going to law school, applying the law. But they will not learn that in law school. They will not be able to think differently as judges unless they get to experience it and unless they are given the opportunity to think differently. Third, something the Judge Cruz mentioned earlier, funding. Dependence on local governments, dependence on local governments to provide buildings, equipment, expenses. That is a reality that actually makes judges vulnerable to pressure. The old saying is you can't fight City Hall. That's absolutely true. If you're a judge and you're handling a case where the local government is involved, where a policy, an ordinance is involved, you can't fight City Hall, right? Fourth, there should be specific remedies available to target areas where judicial independence would be threatened. Attorney Ray mentioned earlier practice of red tagging, of course, killing of lawyers, killing of judges, killing of prosecutors. This is an area where, more specifically, the Supreme Court should come in. Its Committee on Human Rights has been formed, but I think the more pressing question should be what would need to be done in order to preserve and protect judicial independence. Perhaps should we be looking at a specific rule or a specific remedy to protect judges? On the legislative side, of course, there are former members of Congress, future members of Congress here. Maybe should we be looking at it as a specific instance in terms of the commission of a crime? Should it be an aggravating circumstance if someone is targeted for doing their job as a lawyer, as a journalist, as a doctor? Should that be legislated? Perhaps that might make judicial independence, that might safeguard judicial independence more. The fifth is this is more conceptual and philosophical, And so I'll ask for your indulgence for a few minutes here. The tension between courts being passive and active. There's always been that debate, you cannot be an activist court. You have to be passive. You have to wait for the case to get to you. You cannot express an opinion outside of a case, right? But the question should be, can courts be absolutely impartial? Does independence mean absolute impartiality? I do not believe the courts can be absolutely impartial, because if courts are sworn to do justice, then justice means being partial. Being partial in terms of rights, being partial in terms of who deserves more, in terms of what the law provides. And so, yes, we're not talking about absolute impartiality. Perhaps we're talking about being non-partisan, but certainly not being absolutely impartial. So, should courts be simply passive and wait for something to get to it? Or should it be more active? I wanted to bring in the idea that is advanced in the first Amparo case of spouses Manalo, Brothers Manalo, Secretary of National Defense versus Brothers Manalo, which is now incorporated in the Supreme Court's decision, as it were, on the Anti-Terror Act and its own rules on the anti-terror law, which is effective judicial protection. And in that particular principle, which I think borrows, although not too much, from the European definition of effective judicial protection, it tells courts to be proactive. But to what extent they can be proactive, that still has to be determined. So again, courts would hedge their bets. How far can I go here? How far can I go to protect this person, even without a case being filed? I'll give one example. A person was recently arrested in Taguig, an animal rights, a vegan activist was recently arrested. He's still in jail. We're helping him out. The resolution, he was in jail over the weekend. He's still in jail now. We're trying to bail him out now. The information was just filed. His specific condition is that he's a vegan. And we were told that we cannot bring in food, right? So how proactive do you do if you're a judge, right? He believes in veganism. He cannot take any other food. We've asked, can we bring in food for him? But since there is no case yet filed in court, where do we go? How proactive can a court go, right? Without being not independent. So I think those are evolving definitions we need to look at. Last point, and I'm sorry I'm taking too long. I think we should evolve to an understanding of courts as rights-based instruments rather than just law-based agencies. Again, it is easy to just simply apply the law because that's what the law says. But if the problem is the law, but the judge, by applying the law, becomes part of the problem, not the solution. So I think, forums like this, judicial education, training, would help a lot in terms of making judges more independent in their thinking, because they will now be able to evolve to a point wherein they don't just simply apply the law to a given set of facts, but look beyond the law and take a look at rights. Take a look at what we would probably call a higher set of norms. The idea of justice, the idea of equality, the idea of fairness, not just simply legality. So thank you. Thank you for listening.
Thank you, Professor Te. And it seems also that with the last point that you were mentioning on the active courts, it links well also with one of the first remarks that you made on the need to create safe space for judicial agency at lower levels, and not only abiding to what the Supreme Court says or the legislation says, but judges that are free to push for interpretations of the law that are more rights-centered. Very, very interesting remarks. Thank you, panelists, for your contribution. And now I would like to move to the final part of this panel, where we will give you some background on the fact-finding mission that I already hinted at before. This fact-finding mission, it's called Caravana Filipina. It just concluded its phase 1 activities, which took place over the course of the past 2 weeks. a delegation made up of 12 lawyers representing 10 lawyers and human rights organizations traveled to Cordillera, Iloilo, and Cebu to gather evidences and testimonies from Luzon, Visayas, and the Mindanao region. And now a representative of the fact-finding mission delegation, my colleague Hans Gansbeck, will tell you more about the background of how this initiative came to life. Hans is a Dutch attorney, co-founder of another initiative that I'm sure many of you are already familiar with, the Day of the Endangered Lawyer. So please, Hans, the floor is yours.
First, I have to change. Oop. Sorry. Hello, dear colleagues, dear friends. I'm Hans Gaasbeek. I will not speak about our final report, which was published yesterday at the press conference, but I advise you really to read it very closely. Ah, it came down. Thank you. Could you hear me? Okay. But the situation of the human rights in the Philippines is still very alarming, and it has not much changed until now. But I want to refer to our report. As founder of the Day of the Endangered Lawyer, and also starting with a Philippine colleague, Tsarina Musni, the first plan of this mission, I was asked to tell something more about the relation between those two events. I was first invited with a group of lawyers and judges from Holland and Germany in 1990. And this invitation was done by the flag lawyers, who are still existing in the Philippines. Herman Veerbeek, my colleague, he's in the back there of the room filming. He was also a part of this mission. And we were driving for hours and hours on the EDSA and a lot of other roads which were already completely blocked. So we had, during our ride in the car, we got a lot of colleges from Romeo Capilong, one of the founders of the NUPL. And this was an inspiring man. And when I came home again, from that moment, I started with picking up the human rights work. He was inspiring, but also the situation we met there then in the Philippines was also very inspiring to do more for at least the colleagues and the judges and the prosecutors. We also visited Satoru Campo, who's present here today. We visited him in prison then, and this was also a very inspiring moment. So I want also to thank Satoru for his inspiration. He was very calm, very strong when we visited him, and I'm so glad he's here now and that we could meet again, and also that he has done so much also in the meantime for the human rights in the Philippines. When we came home, I started also working for the Commission Defense for the Defense of the European Democratic Lawyers. And this organization I'm still a member of, just like two of our members of the delegation, like Frederick Uriel, who's in the room. Hi, Fred. Many years we wrote letters, we organized international meetings, and we wrote reports. And one day I took a shower. Because you don't have much time for that. No, I'm joking. But your human rights work is always, it's never finished. No, I took a shower, and during this pleasant waterfall, this idea came up. Why not create an International Day of the Endangered Lawyer? This day, in my vision, it would take place one time a year, the 24th of January, and all lawyers in many countries, in solidarity with their colleagues, should undertake action to ask attention to the lawyers, especially in one focus country, where human rights lawyers suffer under threats, persecutions, and attacks. And we should offer petitions to the embassies of this focus country. Last year we supported in this way the lawyers in Iran. And the next year we have to choose on next June 20, when all our organizations which are involved in this day, it's more than 40 international human rights and lawyers organizations, they will choose the new country for 24th of January 2025. In 2015, our focus country was the Philippines. So in many countries over the world, we offered the same petition to the local Philippine ambassador. And also lawyers were demonstrating in Rome before the embassy to focus on the difficult situation at that moment of the Philippine lawyers in 2015. And on that day, also one of my inspirators, Edre Olalia, NUPL president, he was also with us in The Hague when we spoke to the ambassador. In the Duterte period, in 2019, our Foundation Day of the Endangered Lawyer tried to organize a new fact-finding mission to the Philippines together with IADL. And IADL is a worldwide organization of democratic lawyers. And we reported about the many human rights violations. We reported about the red tagging. And at that time, we also concluded that President Duterte also played a bad role in the red tagging of the lawyers. And after that mission, I felt kind of frustrated more and more because, well, we couldn't do much, we couldn't achieve much after this mission. In this very dark Duterte period of suppression of the Filipino people, and also the suppression of the lawyers, judges, paralegals, we came up with the idea of a Caravana Filipina, and we developed this plan. The idea of the Caravana does not mean that we travel in a group and that we investigate, but also that we will come back after having received reactions, after we have studied many cases, and after we have received comments on our final investigative report, which has to be made still. And then we will come back also to see if the human rights situation has become any better. Last year, the NUPL discussed with us the project plan, the Caravana plan, and agreed that it should be done. And there are more than 10 organizations, the ones who are mentioned in the press declaration from yesterday. All these organizations supported the Caravana plan enthusiastically, and we started to cooperate. And well, like some 2 weeks ago, we came with our group of 12 to start the investigation in Manila. And after that, we went into groups to different parts of the country. And we were all very, very motivated and committed to come here in solidarity with you and to investigate the current situation in which lawyers, prosecutors, judges have to work, but also many other professions, journalists like Saturo Campo, human rights activists. It's very alarming, like I said. We were very happy that filmmaker Jacco Groen, he was asked by our foundation to make a documentary about this mission. Jacco Groen made already more documentaries about situations in the Philippines. You can find him on the internet. He's really a very motivated, very sympathetic and very good filmer. He's also filming with his heart, you could say. So we were very happy that Jacco Groen came with us and also took part of the Caravana activities. Well, the first findings are very disturbing, which you maybe have heard in the press declaration. I will not go in deep now, also because of time, but it seems that still, also after the Duterte period, the lawyers, their safety, the judges, their safety is absolutely not guaranteed or safeguarded, and threatening and killing seems to be continued as before, and is still promoted by red-tagging. And prosecution has until now nearly never led to even a solved case. The state of law in the Philippines seems to be in great danger still, and we wish all human rights defenders and human rights lawyers much strength and courage in their difficult work. Thank you.
Thank you. Thank you very much, Hans. And we will now have the screening of a preview of the documentary that Hans mentioned in his remarks. We want to pay a special tribute to our Dutch documentary filmmaker Jacco Groen, that followed the fact-finding mission and has embarked on a journey of sleep deprivation over the course of the last 2 nights and days, just to be able to collate an incredible amount of hours of raw material in the preview that we'll be screening now. And maybe we can just leave the stage free for better visuals.
Because he was a human rights lawyer. And when you're a human rights lawyer during the time of Duterte, of course, you're gonna be red tagged.
I want to focus on those 70 lawyers killed during the Duterte administration. It never happened before.
I think when I was in my first year, I remember we heard like news of 2 lawyers shot, and it was your first taste of like the legal world, you know, the real world and of being a lawyer in the Philippines.
So it's as if my left hand has been clipped, has been cut with her absence. That's how I am angry with the state in persecuting her and the rest of the people's lawyers in the Philippines. We are just doing our job as lawyers, as officers of the court. Yet we are the ones persecuted. And for whom are you persecuting us? Whose interest are you serving for you to persecute? Who is behind you? Who will benefit you? Who will benefit your attacking us?
But why do you have to shoot her 8 times? It's just fortunate for me that she was not hit in the face. My wife is very beautiful.
And specifically in the cases of Attorney Ramos and Attorney Guillen, which were the key findings of your separate investigation?
In the case of Attorney Ramos, was closed, was archived and eventually closed, although can be reopened for lack of witnesses, no available witnesses, no identification of the alleged perpetrators were made by the police.
Ben Ramos was a human rights lawyer. His wife blames President Duterte's government for his death.
They knew who he was. They said Ben, and when Ben looked at them, then they shot. I feel so mad. I don't know. I feel so sad. I feel so just really angry.
Ever since I was in elementary, I would tell all my friends that my father is a lawyer and he's helping the farmers. And he explained to me that the world is really unfair. And when you're poor, you'd really get treated differently than when you're rich, when you're born with money. And so that's why he's helping those people, because he knows that he knows that they couldn't afford the support that they need. And he wanted us to do the same when we got older.
Threats were sent to our parents years before that, and nothing really happened, so we were like...
There were also a lot of other lawyers dying because they were tagged as helping the NPA. So our father was one of those in their lists, including our mother. She was also there at the list, and they published it, they printed it in tarpaulins.
There were pictures of that.
Yes.
And there were flyers also given out. That actually happened like a month before the incident.
And he was also helping with the Sagay massacre.
Sagay massacre.
Yes, during that time, my mother stayed in Kabangkalan City, where my father was killed. So she was handling the investigations, the processes, and we were really afraid for her safety because she sent my siblings to safety, but she stayed there. And we knew that she was the next target and she could die. But she told us that there's no place that's really safe, especially that a lot of people know, and maybe there were intels following her, so there would be no difference if she went out, if she got out of there, or if she stayed. So if she died, then
she didn't want to stop what she was doing. She wanted to continue because she said it was the foundation of, that's where they started, my father and my mother. And it became the foundation of their relationship. It was something common, that they wanted to help people.
For lawyers to be killed, attacked, it means that there's a high level of impunity, of non-accountability, of non-recognition of the need to draw out or to eliminate the basis of non-recurrence of crimes or human rights violations, because lawyers in the Philippines are usually highly regarded. They are in the legal profession. They provide legal service to various communities and individuals. But if you're a human rights lawyer in the Philippines, it means that you're treading on dangerous grounds, because whether in court or outside of court, it is imperative for you to speak truth to power. And that truth is about the experiences of the clients that you defend or that you fight for.
Yes, there are several cases that we're handling today. Ordinary farmers accused of illegal possession of explosives and firearms. Possession of explosives is considered arson. It is unbailable, and once convicted, you are to suffer the penalty of at least 20 years.
They were banging down on the door like, oh my gosh, when you said that actually I don't know if that their plan is to arrest us or to kill us. You don't know at that moment, because they didn't even introduce themselves. They didn't say who they were. We keep on asking, I know my rights. That's the worst thing about it, because you know your rights. You can't do anything. No, you're not supposed to do this. You're supposed to have presented me the warrant before you entered. You're supposed to have had me acknowledge you. You're supposed to have told me. I could have called my lawyer. They took my phone. I was holding my phone. I was trying to record them when I opened the door. They took my phone away. When they had tied me, my husband and they stationed a woman police officer beside me. But every time I look back, she forces to keep my face in just the direction of the wind, where the rest of the unit is behind me. So I couldn't see anything. And I think that's been a problem with a lot of cases like this, because we couldn't win a case of planted evidence. Because we didn't see them planted. My lawyers already discussed this with me if I'm going to do an encounter, so we couldn't even win that because we didn't see them planted. Just so that it wasn't there before it arrived, but we didn't know how it got there or how it, because we didn't see it.
Common farmers, just 3 farmers, and they were charged of having ammunitions and helping the rebel groups. So the community knew that they are common farmers. Why are they charged? And they are now languishing in prison for so many years now. So there is that is injustice. And so we have to address that as lawyer, because our law book says that we should not just be championing the law, we should be championing the cause of justice. That is why we are here and continue on working.
This graffiti was on the holding wall along the road from Manolo Fortich to Bukidnon Midway. This is 6 to 8 feet high wall. This is about 5 meters length. The printing of Musni, Zerate, Tabacon equals NPA during election time. So that's one form also of red tagging Serena. Another red tagging means is the use of tarpaulins. These are black plastic materials hang on streets, major thoroughfares in Cagayan de Oro or elsewhere. The communist group and lawyer of NUPL and UPLM. She is a full-time member of the Communist PKP, that's Communist Party of the Philippines, and New People's Army. She's not a lawyer anymore. She's a combatant now, being a member of the New People. That's what endangers her, being identified with the combat forces of the New People's Army, making her a legitimate target attack either by the AFP or the vigilantes. As initial action, we also have CCTVs installed, because after this consistent red tagging, vehicles will park outside our homes, no plate numbers, very dark, and then wouldn't pull down the side mirrors. They will just park outside our homes.
I was there at 7:30, carrying my bag. I was wearing high heels. And when I reached the second floor, there is a swarm of army. Swarm? Why swarm? One platoon of army is around 30 individuals, and I can see them one by one at the hallways of the court. So what will I do? Will I walk back and run away? So I have to compose myself and walk in front and sit on front. And when I attempted to open the door of the court to get entered, it was still closed. So I looked to my right and looked to my left, and there are army people, and they are all staring at me. Perhaps I just think of that they are just staring at me, but I can see them. But really to pursue what is just, because I have still that belief that something else will work within the framework of law, because I chose to be a lawyer. Well, yes, I fear not only for my life, but for my two children. Yes.
I had noticed the year before that I was already being followed from my home to the court, where I would, I would usually go to court every day in a week to attend hearings. And I noticed that on a couple of occasions I was being followed by individuals by men on motorcycles who would be there outside of the courtroom even after my hearings were concluded. So there were a couple of incidents, and there was one particular incident where it was reported that there were people waiting for me where I had parked my vehicle. So that was the time that I decided that I had to move out, to look for someplace else to stay for a while.
Sa kuha ng CCTV, kitang tumatakbo ang isang lalaking hinahabol ng dalawa pang naka-face mask at sombrero. Nang madapa ang lalaki, inabutan na ito ng mga sospek. Binugbog at sinaksak gamit ang screwdriver.
The whole time that I was on the ground, and I was trying to defend myself. So I guess that's also one of the reasons that none of the blows really were able to puncture my neck. They were able to hit me in the neck, but they weren't deep wounds. They weren't deep cuts, except for the final blows that landed on my hand. Now, because I was no longer able to defend myself at the time, they managed to hit me well at the side of my head here. And in the final blow, the screwdriver, the weapon, was embedded at the side of my head. Fortunately, it hit a particularly hard part of my skull, so it didn't go through. It wasn't able to go through straight to.
And we are aware that many of you may know personally some of the courageous individuals that you've just seen on screen. We have some family members here, and I'm sure also many of you were colleagues and knew well the brave lawyers that are mentioned in the documentary, and we hope you will watch the documentary when it comes out in a few months. While the documentary highlights for sure the grave human rights violations targeting the legal profession in the Philippines, we found that it also shines a light on the unwavering commitment of these lawyers to a system when even the most marginalized and oppressed in society can receive justice. And it became immediately clear for us that this light, the light of their invincible courage and resilience, shines brighter than fear. And so it is our immense honor and pride to stand in solidarity with them in this quest for justice. And as I bring this panel to a closure, I wanted to thank the amazing panelists for getting us off on the right foot for the rest of the day. And we will now have a 10 minutes coffee break before we resume the discussion with the panel number 2. Thank you.
Sí, sí. Okay. Hello, everybody, and welcome to the session 2 panel, targeting lawyers, journalists, activists, civil society organizations, and other human rights defenders in the context of counterterrorism, anti-drug, and related policies. My name is Gonzalo Sáenz. I am a Spanish lawyer based in Madrid. I am here representing the International Observatory of Lawyers in Danger. Our organization main aim is to uphold the free practice of lawyerships and also to promote the rule of law. In order to do that, we have some protection programs for lawyers, and one of our main activities is doing also fact-finding mission as the Caravana Filipina. Today, we are going to discuss the loss of rights on pursuit some order laws here in the Philippines. It was Eduardo Galeano who entitled this term sacrificar la justicia en los altares del orden, sacrifice justice in the altars of the order. And I think it's not so far of that we are going to analyze here today with our experts. Carlos Conde and Cristina Palabay are going to speak firstly with me. We are going to be like an interactive panel, and I'm going to do them some questions, and they are going to answer me. At the end of this panel, we will have the final keynote speech of Professor James McAdam, who will be substituting Mr. Ben Sol, who has just returned from Africa and told us that he really feels unwell, so he will sadly won't be able to participate in this panel. I would like to invite our speakers to the stage. Thank you. Thank you. And I'm going to present you, if you are okay. There's the mic, if you want. First of all, we have Cristina Palabay. Cristina Palabay is the Secretary General of Karapatan Alliance Philippines, a national alliance of human rights organizations, desk and individual advocates working for the promotion and protection of human rights here in the Philippines. She is among the laureates in the 2021 Franco-German Prize for Human Rights and the Rule of Law, and a finalist in the Martin Aslet French Human Rights Prize in 2018. She is also a regional council member of the Asia-Pacific Forum on Women, Law and Development, and a board member of Civicus. Through her years as an activist, and as many of her colleagues in Karapatan, she has faced death and rape threats, surveillance and judicial harassment, presumably because of her staunch defense of human rights, of women's rights and people's rights. But she continues to do her work as a human rights defender. Thank you, Cristina, for being here. And we also have Carlos Conde. Carlos is a senior researcher at the Asia Division of Human Rights Watch, covering the Philippines. With a focus on research and advocacy on the ongoing war on drugs in the Philippines, he has documented extrajudicial killings of activists, journalists, legal professionals, peasant leaders, environmentalists, and indigenous people, as well as allegations of torture, enforced disappearance, and press freedom violations. He currently serves as a board member of the Center of Media Freedom and Responsibility and a member of the International Advisory Board of the Indigenous Peoples' Rights International. So thank you for being here. As I told you, we are going to be a quick panel, an interactive panel, so I'm going to do you some questions, and then you will answer us with all your knowledge about this matter. So, first of all, I would like how these new laws, how these anti-terror, anti-drugs, and other policies to ensure order here in the Philippines are affecting human rights and people's rights here in the Philippines.
Thank you. I think Tinay will be more capable in answering that, but one thing to keep in mind about these laws, and we have several of them, the anti-terror laws or issuances, and some of them have been referred to by our speakers early today, are quite a heavy burden on not just on lawyers, but practically everybody, advocates, journalists, rights defenders, indigenous peoples, and also the poor. I mean, the most, I think, grave example would be the drug war, where we now have thousands and thousands of killings. I mean, there's still some debate about exactly how many we're talking about here, but I think it's not anymore debatable that we're talking of thousands and thousands. The Philippine government is willing to accept that there have been 6,252 deaths by the police under Duterte. And these were all operationalized by policies and laws of this government, foremost of which is a very draconian drug law that we have in the Philippines. And this is something that authorities are really exploiting to the hilt. This is something that tyrannical leaders like Mr. Duterte are really exploiting for whatever purposes. So we have that. That's kind of the dangerous drugs law in the Philippines is probably one of the most oppressive drug laws in the region. To cite you one example, the dangerous drugs law actually makes it illegal for anybody to purchase a needle and a syringe without a prescription. That's just one. And also, of course, we're talking also about the amount of illegal drugs that anybody can be caught with, and that amount will determine whether, you know, how hard the recommendation is for penalty. So, and many of those who are caught in the trap of this draconian law is, many of them, most of them, in fact, majority of them are poor people who don't have access to representation, to legal representation. And I really want to point this out, that this is such a great opportunity, this event today, to highlight one of the key problems that we have here. And Attorney Olalia referred to this earlier, which is access to justice. It's not only that people are being killed. The victims, their families, are not able to access justice for a variety of reasons. So this makes this a very important one. And also, of course, back to your question, there are existing policies that were first implemented by the Duterte government that are still being implemented by the Marcos government. The most, I think the biggest one being the policies on the drug war, which have not been rescinded by Mr. Marcos, regardless of what he says about the drug war, about how humane it has become and how, you know, things have changed. None of that matters if the drug war as a policy is not rescinded. So I would stop there.
Thanks, Galoy and Gonzalo. Well, in the first place, there's a blueprint for disaster. There's a blueprint on the use, I'd refer to it as the use of counter-terror legislation, because most often it's often referred to as misuse, or there's just the wrong way of implementing it. But in our analysis, these counter-terror policies and laws are really meant to do what it is intended to do, and that is to kill dissent. That is to kill the exercise of rights and freedoms. And it has happened in many, many countries all over the world, as what the independent expert George Catrogalos has mentioned a while ago. Here in the Philippines, the blueprints are there. You know, there's the national security policy of the previous administration. Duterte has drafted and came out with the national counter-terrorism strategy when the anti-terror law was passed in 2021. And then, of course, the current administration has drawn up its own national security policy. And if you look at that, it's literally a cut and paste. The contents are cut and pasted from the Biden-Harris national security policy from 2022 to, you know, as long as I think Biden is there, no? But it speaks of numerous things. It uses the same buzzwords: neutralize, whole of government or whole of nation approach, terrorist fronts, etc. Which means the goal is still to use the terrorists or communists or whatever is labeled people right now who are exercising a right to dissent, no? And paint them in a corner, paint them to be subjected to various forms of attacks. So those kinds of blueprints are there. The Anti-Terror Law and the Anti-Terrorist Financing and Suppression and Prevention Act is there since 2012. No? And the impacts on civic and democratic space are absolutely disastrous. No, killings, contrary to what some might hear, I keep hearing that, especially among circles, that the view of the current administration right now, the view is that Marcos is better. Marcos Jr. is better than his predecessor, Duterte. And he's better than his father. But we beg to disagree because what is happening on the ground is a lot different from all those rosy words. Number one, extrajudicial killings in the name of counterinsurgency. We documented 99 under the less than 2 years of Marcos Jr. And 80% of those who were killed are ordinary farmers, farm workers, indigenous peoples, all said to have been involved in military encounters. So they were said to be, the military accused them to be armed rebels. But these are ordinary folks whose bodies, when they were killed, were laid down in, you know, some grass, and then guns were, the scenes are staged to make them appear, to make it appear that these people, they deserve to die because they're armed rebels. So this thing continues, and even one of the recent reports involved a young lumad in Sultan Kudarat, who, along with friends, have just been, you know, they're just walking in the fields, and then they were killed by the soldiers. And then an amicable settlement apparently has been achieved, because there's simply no way, as the community said, that they can grapple with the impunity that's in the area. Aside from killings, enforced disappearances continue to occur, and I think this will be tackled by the next panel. But I'd like to emphasize that the abductions and the enforced disappearances right now are also because of the weakness of the law. We are one of the countries in Asia with a law against enforced disappearances. But the funny thing is, when this is being reviewed in Congress, someone, I will not name him, a government official was my seatmate, and he was telling me, you know what, Tinay, all those human rights trainings, all those inputs on the anti-enforced disappearance law only made the state forces knowledgeable on how they can go around it. And they really went around the law, because under the said law, for example, enforced disappearance is a crime. secret detention facilities are illegal. But look at where Junila Castro and Jed Tamano were brought. They were brought to a hotel. They were brought to Dayan Gumanao and Armand Dayoha. Where were they brought? To a beach resort, and then to a house in some subdivision in Negros. So secret detention facilities are rifely being propagated outside the camps, outside of the official detention facilities, but it doesn't mean that these people are, being treated very well. So that's how they are going around the law. Illegal arrests and detention continue, and we are looking at 361 arrests under the current administration. There are nearly 800 political prisoners. 106 of them were arrested and they're still detained under the current administration. But more and more political prisoners and human rights defenders are facing charges using the twin terror laws, the anti-terrorism law and the law on terrorist financing, which makes it very, very, in a sense, subtle kind of persecution, but at the same time dangerous. 112 individuals are now facing complaints or charges using the said laws. And this is not to count the other NGOs, the other development organizations whose bank accounts have been frozen because their board members are charged, are facing criminal complaints or charges under the said laws, or the Anti-Money Laundering Council just imposed an arbitrary decision freezing their accounts. So what are we saying? The impacts of the said blueprints, counter-terror blueprints and laws are changing the fabric of how these laws are implemented, how the current landscape, the human rights landscape, and at the same time, how the judiciary is being used to go after human rights defenders, lawyers, and everyone, journalists, who would speak truth to power. And it makes, I think, the current situation, the current administration, we are in a worse position. It is not any better because precisely of these laws that have been put in place and are being continued under the current administration. So we dare say nothing has changed. It's still as bad or perhaps worse than before because the infrastructure, the laws has made them worse.
If I may quickly add, Gonzalo, if I may. It's not just even a question of actual laws that are being, some would say misapplied in many circumstances. And we really need to challenge that this is a simple case of some functionary in a government at the DOJ misapplying or misusing or not understanding the law. There's a method to the madness, to all of this. And Attorney Cortez earlier pointed out that even at the lowest level of the prosecution, it starts there. You can see the pattern of how civil society actors are being targeted by the judicial system. So that's that. But then there's another aspect here, which is even more troubling, I think, particularly for indigenous people's communities, which is that there are certain, for instance, is the NCIP quasi-judicial? No, it's not, no? Yes, it is, right? So bodies like the National Commission on Indigenous Peoples, they're now pushing to amend the guidelines on the free, prior, informed consent, which is crazy. The amendments that I read basically got the FPIC to make it pointless. So that's one example of government policies and issuances and laws. And I mean, NCIP is a constitutionally created body that is being undermined by efforts like this. So that needs to be, I think, also highlighted.
Okay, thank you. You were talking about the current Marcos administration. You were bringing up some data at the table, you, Christina. I would like to know, with this super body with this new super body for human rights, it's a difference with this super body? It makes a difference, a real difference, or not for you?
So thank you. But I'd like to add 2 points to my earlier point. One is on the absurdity of the use of the counterterrorism law. There are 2 examples I'd like to give. Number 1 is on the recent cases of our human rights workers in southern Tagalog. These are 2 young paralegals who were assisting political prisoners. And they went to, after an arrest, they went to these 2 environmental defenders who were detained, and they gave 500 pesos just for, upkeep, and food to the detained environmental activists. The next thing they knew, they are facing charges under the Terrorist Financing and Prevention Suppression Act. Imagine 500 pesos, and food just to provide some relief for those environmental defenders who were detained. The second example I'd like to give is on the cases of the development NGOs who have been facing freezing of their bank accounts and some, I think many criminal complaints or charges. The case of Sernet in Cebu is a very prominent one, considering that there are more than 27 who are facing criminal charges. And Sernet has been known to provide various forms of support for local farmers' communities. And they're being hailed to court for some rumor, based on some accounts of supposedly some rebel surrendery, or people who have been said to be rebel surrendery. So, what am I saying? It's very easy to invent stories. But if you look at the evidence, that's all they have. These are just stories without any leg to stand on. And meanwhile, communities are suffering because the NGOs can't deliver services like they used to. Those in jail are unable to be given food because people are afraid that they'll be facing the same charges. Which brings me to Marcos. We've had so many task forces already. We've had Task Force AO35. We'd have Task Force USIG a long time ago. Come again? The media safety, I leave it to you. But we've had several task forces. And not one among those task forces showed significant output or impact in terms of accountability. AO35, we would say, is really a failure. Imagine you have you're looking at more than 300 cases, and the government has only managed to prosecute how many? 13 perpetrators out of the, perhaps thousands of perpetrators from those 300 cases. So with this new super body, we don't think that it will be any better. In fact, we think it's smokes and mirrors, plain window dressing, and this is the second task force that was created under Marcos. The first, I think, was last year on workers' rights, and I think what the output, the impact is very clear, especially to grassroots communities and victims and their families. No justice until now, and all these things will just be for show, maybe for the international community, as President Marcos is set to campaign, is actually campaigning already for a UN Security Council seat in 2027 to 2028. That's the dangerous part. When all you need are optics and nothing, no improvement on the ground.
Yeah, my take on that is a bit harsher probably. But as far as accountability is concerned, this super body is a sham, to be honest. It's a sham. I mean, you have here a super body that's composed of government agencies that are responsible for many of these abuses. How can that be an accountability mechanism? It's not. It can never be an accountability mechanism. Having said that, though, we have to keep in mind that this super body is being spun by Malacanang as an extension of the UN Joint Program, okay? And the UN Joint Program, sadly, was not renewed. And Malacanang decided to own the program by creating this super body with the intention of continuing the good stuff, the good things that the UNJP managed to do. And we're not going to quibble about whether the UNJP was a success or not. But again, it is a good effort for long-term institutionalization of human rights and all of that, but the need of the moment, and this is something that we've always told the UN, even before in Geneva or here, the need of the moment was accountability. And the UNJP was a failure in that regard. It's not a failure in terms of, for instance, training police officers to be more respectful of human rights or training them to be more efficient. I wouldn't go to that extent, but in terms of accountability, in terms of pressuring this government to do something about the killings, to stop them, to investigate them, to prosecute, to convict, it is an utter failure. Now, if the government intends to now continue with the UNJP as this super body, of course it can do that. It can still conduct education campaigns about human rights. It can still train police officers. But again, the need of the moment is accountability. Thousands and thousands of Filipinos are still crying out for justice. Why is that not being addressed by this government, by the previous government, and by this government? This government is doing a lot of press, a lot of spinning about the human rights situation in this country. And the international community is just so happy to listen to all of this because they were so sick and tired of Duterte before, cursing them. And hearing Marcos now saying that, oh, we commit to human rights and all that, who wouldn't want that? Of course people would want that. Who would disagree about the idea of improving human rights in the Philippines? Nobody would dare disagree with that. But the problem is that is not the utmost need of the moment, as I keep saying. So, again, as far as accountability is concerned, this super body is a sham. There's no other way to describe it.
Thank you. Thank you for your responses. Anything to say, Christina? Anything more to say?
Later.
Later. Okay. 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 So, as you may notice, some international delegates and international embassies are here because the Philippines has become one of the main concerns of the international community. And I would like to know actually what the international community could do for the Philippines, because we have now the speech of Professor Jane McAdam, but I would really want to listen from you. What do you expect for the international community?
Well, a few things, but let me make this quick. I think the significance of the International Criminal Court coming in, investigating all of this, prosecuting whoever they need to prosecute is of utmost importance. For the simple reason that practically all the other mechanisms to seek accountability have failed. We're now down to the ICC, to be honest. The UN, with due respect to the good work that people are doing there, in the human rights work of some people are doing there in the Philippines, the UN is, they need to enter into compromise with the Philippine government. And we need to recognize that. I don't think there's any way around that. It's a shame, of course, but I think the ICC needs to really make good on its commitment in the Philippines. The UN still needs to really continue monitoring the Philippines. The EU needs to shape up. Its GSP Plus is a failure. It's another sham, as far as I'm concerned. Now it's getting into free trade agreements negotiation with the Philippine government. That's fine and good, but we're not hearing any reference at all about how human rights is going to be integrated in these negotiations. There's just not a lot of, conversation going on about these things. Filipinos are in the dark. So, really, the international community needs to really shape up about its policies on human rights in the Philippines. We understand that they were so, wary under Duterte, but that is all past now. So, we expect the international community, the EU, the UN, the US, Canada, Australia, to really now take this problem by the horn and deal with it, and don't stop tiptoeing around the problem, because killings are still happening as we speak. Almost 700 now have died in the drug war under Marcos, and nobody seems to be talking about it. Activists are still being targeted. Journalists are still being harassed. So really, a lot of the good, hosannas that Mr. Marcos has expressed toward the international community, that's all okay, but really, they have to make good, that the international community need to make good on their human rights commitment in the Philippines, and not just words.
Well, as for states, and the states are members of Human Rights Council, I would exhort our good friends in the diplomatic mission to take off the blinders, because it's one thing to have a different president who's not cursing at you, but it's another thing if rhetoric is just the criteria for really working on something as universal, the policies on human rights. And while, of course, many are expecting the ICC, in the UN system, there's also some recommendations which we can pursue, including the recommendations of the two special procedures who have gone here in the Philippines on official visits. The Special Rapporteur on Climate Change and Human Rights. We're expecting the report this June in Geneva. And next year, the report of Special Rapporteur Irene Khan on freedom of expression and belief, on freedom of expression, especially as one of the key recommendations of Irene Khan is on the release of journalist Frenchime Cumpio, who remains to be incarcerated, and many other things. The common recommendation of the two special procedures are on one, the abolition of the NTF-ELCAC. I don't know where that is going right now, and President Marcos said that he won't, but we should, make our voices ring louder when it comes to pushing for these recommendations. The second is on the anti-terrorism law. So in those two recommendations, the rapporteurs will be given a chance to, provide information before the Human Rights Council. There are also strong recommendations of treaty bodies. So what am I saying? In the Human Rights Council, people might think that pressing for independent investigation will gain no ground, but we continue to call for that because there's simply no other mechanism. What can we use? There are even special procedures that we talked to the past months who are also frustrated on the lack of things that they can do within the UN to pursue some impact and changes on the ground. So it comes to, I think, when it comes down to it, the international community is also composed of the peoples that we work with, the ones that we build solidarity with. And I think the various organizations that worked on this day, the International Fair Trial Day, is in a position to move forward the work of lawyers in establishing international solidarity. I remember many years ago, Special Rapporteur Philip Alston came here in the Philippines. No? But what pushed the Philippine government to invite Philip Alston was a whole lot of killings, but at the same time campaigns at the national and international level of various groups and solidarity groups and organizations. So the point on building solidarity, I think, is more relevant right now, because these various efforts can really make a difference, not only for doing something at the multilateral institutions, but really providing moral and political support for those facing difficult situations on the ground.
Thank you so much for your answers. Now we have our keynote speech. I don't know if Mrs. Macadam was able to connect already, or do we have Mr. J. Macadam? No? No? Not yet. Okay. It's not yet. Okay. So I'm going to do some more questions. Yes. Yes. Or maybe if anyone wants to make
blood pressure higher.
Yes. No. My question would be, with all this information that you told us, do you think that in the Philippines could be possible to have a national mechanism to protect human rights defenders?
Well, the NTF-ELCAC don't want a national mechanism. They're very clear about that in the congressional hearings. There's the Human Rights Defenders Protection and Recognition Bill. The lead author of that bill, and the first one who filed it, is actually in the room, Congressman Saturo Campo, in 2007. And what date is today? 2024? But it's progressive legislators who continue to push forward a mechanism. But at the same time, under the current administration, I don't think we hope that there'll be prospects, but it's 50-50. We're working with local government, some local government officials who are open to having ordinances at the local level for the recognition and protection of human rights defenders. But I think a real protection is really among ourselves. I mean, we've been doing it for so long, and the work really comes from the social movements, the groups, the communities that we have.
Just quickly on that one, I don't think there's any question about the need for a national mechanism to do all of this. And even, I think, the general idea of a human rights program for the Philippines that will address all of these questions. The problem that I see, however, is this inconsistent, uneven approach by the Philippine government as far as human rights is concerned. And I think it's not just a question of competence. It's not just a question of people not knowing what they're doing. I think there's a method to all of this. But also at the heart of this, my personal belief, is that this government and the previous ones, they just don't have a principled position on human rights. They don't have any principled position on human rights. And if they don't have that, anything else that they do is suspect. I mean, when you have a principled position in human rights, regardless of who gets, politically zinged by your action, you'll still do it, or show some semblance of it. But this government does not have that. So I don't think we can expect much from a government that has a very hollow human rights stance.
Okay.
Sorry to be pessimistic.
No worry at all. Okay, I think okay. We already have Jake McAdam, the representative of the UN Counter-Terrorist and Human Rights Office. Thank you very much, Ms. McAdam, to be here. We are very happy to have you here. Can you hear us?
I certainly can. Is the sound all right from your side?
Hear you? Yes. Okay. So you want?
Sorry, I couldn't hear them, but would you like me?
Ooh. Maybe we have some technical problems, could be. Do you hear us now?
I hear you, yes.
So you can start whenever you want.
Thank you very much. Excellencies, distinguished guests, my name is Professor Jane McAdam, and it's an honour to represent the UN Special Rapporteur on the promotion and protection of human rights and fundamental freedoms while countering terrorism. That is Professor Ben Saul. Professor Saul sends his sincerest apologies, but he's just returned to Sydney after an overseas trip and unfortunately is unwell. I would like to convey his sincere thanks to the organisers for inviting him to speak at this conference marking International Fair Trial Day, and for drawing attention, much needed attention, to these globally significant issues. I'll now proceed to read out Professor Saul's remarks, but regret that I won't be able to take questions on his behalf. As Special Rapporteur, he says, every week I encounter cases in many parts of the world where excessive laws to counter terrorism and violent extremism are misused against civil society, including political opponents and dissidents, journalists, minorities, Indigenous peoples, environmental activists, and students. Even lawyers and judges have been imprisoned for exercising their professional functions, including those involved in defending or adjudicating in terrorism cases. In one recent extreme case, almost 50 judges were arbitrarily dismissed by an authoritarian regime, and a new batch of politically compliant judges were installed. Counter-terrorism laws and policies have contributed to silencing dissenting voices and weakening a free media, democracy, and civic space. There are a number of common techniques in the misuse of counter-terrorism laws. First, in the absence of an agreed international definition of terrorism, sweeping national definitions have violated the principle of legality by being vague, uncertain, and overbroad, and thus enabling their arbitrary application to conduct that is not genuinely terrorist violence. In recent years, there has also been a creeping criminalisation of the even more vague concept of violent extremism, or even just extremism, even when it's not violent. Secondly, the establishment of vaguely defined preparatory offences and offences related to terrorist organisations have criminalised legitimate conduct and free expression without having any proximate causal connection to terrorist violence. This includes speech-related offences such as glorification, apologification of terrorism, which restrict legitimate discussion of public affairs. The suppression of speech in many countries in relation to the war in Gaza is just one recent example. Thirdly, organisations and individuals have been abusively listed or designated as terrorist without due process or judicial safeguards, severely curtailing people's rights and often the rights of their families. This has included NGOs, media organisations, and social movements. Fourthly, excessive counter-terrorism sanctions and financing laws, including offences and burdensome registration requirements, have undermined legitimate non-governmental organisations, freedoms of association, assembly and expression, and humanitarian activities protected under international humanitarian law. Fifthly, In the investigation and prosecution of these offences, the criminal process has often been marred by excessive state surveillance powers, including bulk surveillance and spyware, violating privacy rights. As well, arbitrary or protracted pre-trial detention and forced confessions. There is also often denial of access to legal representation, unjustified restrictions on freedom to choose a lawyer, including excessive security clearances, and unwarranted limitations on lawyer-client confidentiality. At trial, fairness of proceedings may be undermined by the use of special or military courts that are not sufficiently independent of the executive or impartial. Secret or classified evidence and other infringements on the equality of arms may further undermine fair trial. Children have sometimes been tried in adult courts. There has often been inadequate participation by victims of terrorism in legal proceedings and a lack of remedies for them. Upon conviction, disproportionate penalties may be imposed, including the death penalty for crimes that are not most serious, as required by international law. At worst, criminal process is circumvented entirely by enforced disappearances and summary executions. Just last week, in one African country, I heard testimony about a victim whose eyes were gouged out, genitals burnt, and body thrown into a national park to be eaten by lions and vultures. The abuse of counter-terrorism measures to target human rights defenders and civil society does not just violate international human rights law and weaken the international rule of law, but counterproductively undermines national security. As Pillar 1 of the UN Global Counter-Terrorism Strategy emphasises, state violations of human rights can themselves be conditions conducive to the spread of terrorism. Respecting human rights makes us safer. The Philippines has attracted the attention of United Nations Special Procedures mandate holders in relation to counter-terrorism measures. I have had productive discussions with the Ambassador of the Philippines in Geneva, and my colleague, the Special Rapporteur on Freedom of Expression, recently visited the country. Concerns have been raised about the Anti-Terrorism Act of 2020, the broad definition of terrorism, the expansion of executive branch authority, and the absence of judicial oversight, as well as apparent lack of due process, violations of privacy, and limitations to the scope of humanitarian activity. Notwithstanding the Supreme Court striking down parts of the legislation as unconstitutional in 2021, concerns remain about detention without warrant, expansive surveillance powers, and the designation powers of the Anti-Terrorism Council. In this respect, I recall the importance of ensuring the necessary safeguards for due process and fair trial under international human rights law. I'm particularly alarmed by the allegations of killings, arbitrary arrests, enforced disappearances, judicial harassment, and targeted financial sanctions against religious groups, human rights defenders, Indigenous activists, journalists, and lawyers for terrorist-related cases. I'm also concerned at the alleged use of red tagging or terror tagging, branding of individuals or groups as being affiliated with or being supporters of the Communist Party of the Philippines and the New People's Army without foundation or justification, causing reputational harm to these individuals and organisations. The chilling effect on civil society restricts freedom of expression, peaceful assembly and association, and the right to privacy of the concerned individuals. And it sows fears that peaceful political activities will be met with oppressive retaliation. At its very worst, red tagging contributes to the normalisation of extrajudicial killing of human rights defenders, and it creates an environment in which extrajudicial killings can occur with relative impunity. Last year, the government of the Philippines acknowledged the concerns around red tagging, indicating that it does not endorse this practice. I welcome the recent decision of the Supreme Court of the Philippines, declaring that red tagging, vilification, labelling, and guilt by association threaten the right to life, liberty, and security. I also acknowledge the critical efforts of the Philippines National Commission on Human Rights, to propose legislation to combat red tagging. I welcome the openness of President Marcos Jr.'s administration to engage with the United Nations and the special procedures of the Human Rights Council through the United Nations Joint Programme for Human Rights, which has operated in the Philippines for the past 3 years, including in relation to counter-terrorism laws. State support for the essential and legitimate contribution that human rights defenders, civil society organisations, journalists and activists make to civic life is crucial if these actors are to undertake their work safely and effectively. In conclusion, my mandate's role is to engage constructively with states to improve respect for human rights, including by providing advice and assistance, and to work with civil society to raise their voices to governments and the international community. I stand ready to cooperate with state and civil society actors in our common mission to ensure respect for human rights when countering terrorism, as well as accountability for violations wherever they occur. Thank you very much.
Room, who has traveled a lot to be here in order to be the shield of human rights here in the country. So I want to inform you that lunch boxes will be served at the entrance, as everybody could be starving right now without the snack. And we will continue our next session at 2:30 here in this main hall. So thank you so much and see you again.